Hello, everyone. It's a pleasure to see you today. Hi, hello. It's Yulia from AmazingHiring here, and we are about to start. As usual, we will wait a couple of minutes for everyone to join our webinar. Here with me today is Eli, our legal advisor.
Hello.
And it's a pleasure to see all of you. So while we are waiting, we have posted a poll just to see statistical data on your attitude towards GDPR. We hope that even if you feel quite strongly about this new legislation today, after our webinar, you will feel that everything is not as bad as sometimes it might seem. Okay. Nice wallpapers, Lai. Okay, guys. As usual, also I would ask you to write where you're located, your city, so we know what is our geographical coverage, and we can say hello to each other from all over Europe, or maybe there's someone from overseas as well today. Okay. Okay, I see that we already have a couple of results. You say that you have already coped with the painful issues. Okay, interesting. So, yes, of course it's June already, so that's how it should be. But don't worry, I'm not going to report your answers to any authorities, even if you say that you still have some problems. Okay, let's see our geography. Tallinn, Estonia, Kiev, Prague, Berlin, Tallinn, Warsaw. Tallinn, we have a lot of people from Estonia today. Thank you, Pirit. I think your post about the webinar brought us a lot of people. Kharkiv, Ukraine, and in 3 days, Hungary. Yes, cheers to everyone with whom we will see each other at SourceCon Budapest within a couple of days. Israel, hi, Budapest, Romania, Amsterdam, Bulgaria, Russia, hiring for EU, Zagreb, Tallinn, London, Israel. Great, cool. Guys, it's such a pleasure to see all of you. And I guess we need just maybe 1 minute because I see that the number of attendees is growing. Just 1 minute. Okay, so 22% of our respondents say that GDPR is not painful at all. Everything is super clear. Maybe some DPOs here, someone who is really inside this whole law. Okay, 70% have coped with all the painful issues. Okay, so then I guess the main value for you today, guys, would be just to double check all the main important things and how it is should be interpreted in terms of your recruitment procedures. And we have one call for help. So we hope we will be able to help with that as well if you still have some doubts. Dublin. Oh, hello, Ivan, Mark, guys, nice to see you here. Okay, so I guess we have about 50% of all our registered attendees, so it's good time to start. For all of you who just recently joined, let me again introduce our legal advisor, Eli. Eli will be the main speaker today because he's really in depth of all the, not just in general GDPR legislation in terms of everything on all the levels of organization, but also he has spent quite much time researching into the GDPR interpretation in recruitment. So I give the floor to Eli, and we are ready to go.
Hello,
Hello,
everyone.
everyone.
It's so
It's so
lovely to see a
lovely to
lot of
see a lot of
countries, a lot of people interested in GDPR. And it's been 2 weeks since GDPR is in force, and probably Probably by now you've been receiving dozens of privacy updates and requests for consent. And it's pretty natural given the extended territorial reach, so that more companies are now affected by the new law, and there is some uncertainty in interpretation of some of the new rules. And all organizations were carefully preparing, and I see that by looking at the polls that all organizations have been preparing to have their processes, policies, and documentation to be GDPR ready. But what GDPR really means for recruitment and the processes around that. So, can recruiters use personal data collected from different public sources? What kind of data can be handled, can be stored? What kind of legal grounds to use, to rely upon? What to say when you're approaching candidates? And can recruiters retain personal data after a candidate has refused an employment opportunity? And basically, the question is how the GDPR principle relates to recruitment. And these are exactly the things that we're going to discuss during this webinar. And in the middle, I would love to take some of your questions. And of course, I will try to answer the rest of them after the webinar. So what are the practical implications of the key 7 GDPR principles for recruitment? And the first principle is, and I believe it to be the most fundamental, it's called lawfulness, fairness, and transparency. And it itself addresses three important aspects. So, what is lawful processing? And apparently, organizations must abide the laws, regulation, and must be able to fulfill their contractual obligations. And in this sense, processing should not be in conflict with such requirements. But there is more. For the processing to be considered lawful, it is essential to identify a valid legal ground, so-called lawful basis. You must determine your lawful basis before you're processing, and you should document it, and of course be ready to inform individuals of that lawful basis you base your processing on. And you must be able to provide this data to supervisory authority upon demand. And let us examine the that in a little bit more details. So GDPR outlines 6 legal bases. I will not focus on some of them that apparently cannot be used in terms of recruitment. But the first is consent. It's when a data subject has given clear consent for you to process the personal data for a specific purpose. And many consider consent to be the core legal basis organizations will be inclined to use. However, imagine you're sourcing candidates online. It is virtually impossible to obtain their consents. How many consents would you need to collect before you find the person you want to recruit? And on top of that, even if you would manage to obtain a consent, it's going to be a post factum consent, and you would state something like, "I consent for my data to be used to consider me for that respective position," which is impossible to obtain. And consent may be used in cases when candidates are already undergoing hiring process. When you approach a person and state, for us to consider your for the role, we need to process your personal data. Please consent to that processing according with our privacy policy and something along those lines. When the person is had been approached and the person is already undergoing the hiring. And one of the cases when you really can rely on consent in recruitment is when you want to retain the resumes of those who failed to proceed to the next stages of employment. The unsuccessful candidates, you need to address them and say, well, can we still hold your data for some specific period because we would like to consider you for another position. Another legal basis is a contract, and the contract is when the processing is necessary to fulfill a contract. or if you need to take specific steps to enter into contract. And well, even though employment contract falls into that category, and all steps required to enter into contract may be used when a person is undergoing recruitment process and is already considered for a position, and you require certain data to complete the contract. For instance, you need to specify the party to the contract. You need to indicate the personal identity number. For other reasons, for other the contract cannot be used as a legal basis for recruitment. The next is a legal obligation. It's when a processing is necessary for you to comply with the law. But here it is very important to emphasize that your contractual obligations do not supersede the fundamental rights of individuals. For example, you cannot have a contract with a company about processing of personal data, about third-party data subjects, and pass that as a valid legal basis. Legal obligation is usually used as a basis if there are more specific laws that require you to process employees' data. For instance, you hired a person, and you need to process data in accordance with accountancy laws, or related to insurance or taxes. And if a person wants to be forgotten, or the former employee wants to use the right to be forgotten, uh, he or she addresses the company and say, uh, "Could can you please delete my data?" But you have a conflict because you have the accountants, you have the law that provides you that you need to store data related to taxes and to accountancy for a duration of like 75 years. And you have a legal obligation to retain the data, even though the individuals have the fundamental right to be erased, to be forgotten. But next is a vital interest. And it is when the processing is necessary to protect data subjects' vital interests. And whereas successful recruitment can be a lifesaver, this legal basis is hardly to be used in recruitment. Vital interest is typically linked with let's call it life and death situations. And next is a public task, is if the processing is necessary for you to perform a task in the public interest or for your official functions. And this task has a clear basis in the law. And unless you're performing a public functions, there is very little practical use for this basis for recruitment. And now we can move to the last legal basis, which is called legitimate interest. And it is when the processing is necessary for your legitimate interest or the legitimate interest of a third party, unless the individual's rights and freedoms override those legitimate interests. And this legal basis is usually challenged and is subject to a lot of speculations. But I regard legitimate interest to be the only valid legal ground that recruiters can use. Just bear in mind that it's not a legislator's intention to kill the sourcing or marketing by limiting companies' ability to find a proper legal basis. Companies would be in struggle of attempting to collect consents or entering into contracts, and frankly, legislators don't want that. It, it one of no sound only on my side. Do you hear me? Okay, perfect. Uh, it so as I was saying that legislators don't want that. It is legislators' intention to force companies to be just careful with data so that companies understand what they're doing, that they apply appropriate controls and consider individuals' interests and enable data subject to use their rights. It's a fundamental thing, and for that GDPR stipulates that you must ensure that you must have a processes to ensure individuals to exercise their rights effectively. That you have a processes to handling requests. That if a person wants to be forgotten or a person wants to know what kind of information you have about the person, and unless there are specific laws that prohibit that, you must provide this information and you must handle the request in a timely manner. But
Elias,
yeah, sure,
yeah,
sure.
it's Yulia here. Just one question. So just to highlight that, because I think that's one of the most important things from this slide. So for us, sources and recruiters, legitimate interest is mainly the most important concept because it helps us to go with the lawful processing.
Yeah.
Okay, cool.
Yes,
Thank.
exactly. I would always lean to legitimate interest. But there is actually an essential part of this concept, and you must be very, very carefully with using legitimate interest, because the essential part of the concept is to carry out the balancing test, to balance between your interests and the rights and freedoms of a data subject. You need to carefully consider the rights and freedoms. And obviously, for recruiters, your interest is your legitimate interest, and just your interest is to find the best suitable candidate for yourself or for your client, and you're willing to search whenever possible to accomplish this task. And this is understandable. But as any legal basis for processing, legitimate interest can only be used to the extent this activity is necessary. But how to assess necessity, how to balance between your interests and that of the of an individual.
Yes, please tell us. That's very important, I think, for everyone here.
Yeah, uh, and and to do that, you need to perform the balancing test. First, identify your legitimate interest, and apparently for recruiters, it's to find the best suitable candidate to assess the expertise you just state the reason why, the purposes, and what you need to think about is, can the purpose be achieved by another means? And can you avoid the processing or just reduce the number of categories of personal data you're using? For instance, if you're using more than is needed for you to have a decision to hire a person, then you don't need these categories to be considered. And think about, is the processing consistent with your legitimate interest? Uh, and then always think about data subject. Always think about the data subject from the data subject's perspective. Are the interests of the individual corresponding with the purposes of processing? And here I would like to emphasize that you should always pay attention to the source you're collecting data from, because the interest of individual may depend on source they're leaving their data in. If it's a professional network, it is easy to prove that by making a profile public, individual expects data to be protected, and including for recruitment purposes. But especially if a person has indicated that he or she is open for a new opportunities, and which is in a case for LinkedIn, for instance, you can just mark that uh, i- there is a functionality for that. But if it's a private closed group, which is obviously intended for family and friends, such source cannot be used. You'll never balance your interest against individuals. Let me see one of the. Yeah, I agree with Iker that it is a gray area, but if you don't have any legal basis, but how else you're going to consider a person for a position? How else you can find a person unless you search in a professional network, unless you have your own strategy of evaluating people. You cannot you cannot collect consents beforehand. You don't have anything to substantiate your claim that you have a valid legal basis. Yeah, but again, the paramount thing to this is to have a balancing test. You must be able to prove that you have a necessity, that your interest overriding the person's rights to the privacy. But you must at all times you must ensure that if the person is objecting to the processing, you can delete data or you can immediately stop the processing. But when you're approaching a person, it's a completely different thing. When you already approaching a person, you can find another legal basis because you have a contact already. And another issue is to think about, can you ensure that individuals can exercise their rights? Do you have a proper ability to ensure right to access, right to rectification, right to erasure, right to object, and right to portability? Because when you're processing data, you must by default think about those things. Then when you have this documented, your consideration and your decisions, then you perform a balancing test to decide whether your interest prevails over data subjects. It's always a matter of how, and it's really always a matter of how you will be able to advocate your decision and justify your processing. Please keep in mind that the result of balancing test must be documented. Um, and they must be available on demand to supervisory authority or data subjects. If you have another processing activity to perform, or you decide to use information for another purpose than that you've indicated as your legitimate interest, you'll need to make another balancing test. Legitimate interest can be an actual for processing personal data, but you cannot use the legitimate interest if the processing can be harmful to individual. And you must always think that if you suspect that individual would have any objections that this would it should can I take one question perhaps, that this is a very hot topic, so let us maybe focus on one of the questions. Should you do that? I believe that it should be a generic. It should be a generic one. Of course, there could be some ad hoc cases in which you find if you're a bank, you need to do a very detailed check, and you may examine more categories of personal data than that for a regular position. You can have well, the not only educational background, but family history and that kind of thing. But as for bank, of course, it's more specific laws. You would even have the anti-money laundering law and legal implication that would mean that you have a legal obligation. But I would use a generic one. But for a specific position, think if you need more information that for regular positions. If you're looking for some CEO or some C class executives, you need to. I would suggest you use the separate balancing test.
Elias, do you think we could maybe share with those who wanted a template of a balancing test afterwards?
Yes, certainly. Yeah,
Yeah.
we have a template. We've developed a template for that with all these questions and result and yeah. Go
Just
ahead.
let us know if you guys need it. Just write to me afterwards, and we would be happy to share that. Thank you.
Yeah. All right, then we come to fairness. And what does fairness means? And in general, fairness means that you should only handle personal data in a ways that people would reasonably expect and not use it in a ways that have unjustified or harmful adverse effect on them. You need to stop and think not just about how you use personal data, but about whether you also about the interest of individuals. And a lot of these principles are interlinked, so I will be talking about the same thing basically. But a fairness test should be the part of the balancing test as well, in which you consider how the processing affects the interests of data subjects and what are the ways of obtaining the data. Can the individual reasonably expect his or her data to be used in this way? And then we move to transparency. And transparent processing is all about being clear and honest about who you are, how and why you're using personal data. And review your privacy notices. They must be easy, accessible, and easy to understand. And the language must be clear and precise, plain. So even a child could understand. And you must include information about your purposes of processing, your retention periods, and who it will be shared with, and of course your lawful basis. Individuals have the right to be informed, and that's an Article 13 if you obtain the data from individual, and 14 if data is not obtained from the data subjects directly. And that leads me to another topic, and how to approach candidates when you found data online and you want to approach a person. And so in your message, you need to state who you are, and the contact details of your data protection officer, if you have one. I would recommend to designate a person responsible for security. And of course, purpose of processing a job offer, and legal basis. If it's a illegitimate interest is your basis, you must inform about legitimate interest. Or we have an interest to consider you for this specific position. Yeah, even you can share the result of the balancing test. And of course, the categories of data processed and to whom you are going to share this data with. If you're a recruitment agency, you would probably be informing about your client. And eventual transfers of the data to third countries, so just say, well, we don't transfer your data um, to outside EEA, and retention for how long you would like to store data, or criteria that determines this period. You shouldn't be like super precise and state, we will store your data for 1 week. No, you can say that, for instance, the data will be stored until the end of the recruitment process, and usually it takes like a couple of months. Yeah. And information about data subject rights with respect to its data, of course. And I would suggest to include the reference to your privacy policy, in which you will have described how you ensure data subject rights, and the rest of the required information about the right to complain. And it can really be a short message that, well, we ensure your right to access, portability, and erasure, and you have the right to file a complaint. And from and of course you need to state from which source the personal data originate, and if applicable, if whether it came from publicly accessible sources, and about automated decision making. And just to summarize this first principle, always have a legal basis. If you rely upon your legitimate interest, identify it, document it, and do a balance test. And always consider the individual's rights. Think about the reason individual left its contact details. Do not collect personal data from sources that are obviously meant for private business. And for instance, closed forums or dating sites. and provide information about your processing activities in accordance with Article 13 and 14, basically in this slide. So Ekaterina wrote that another funny thing is that consent is automatically revoked when a candidate is hired. Yes, exactly. Yeah, the consent is deemed like null and void. Yeah, at the moment it's fulfilled, and I deem consent to be very weak, actually, legal basis, because consent can be revoked at any time. Uh, the second principle is purpose limitation. And obviously, you cannot process data unless you have a valid and lawful purpose. And once the purpose is defined, you process data in accordance with that specific purpose. And you cannot process data in a way that is incompatible with that purpose. For instance, you want to recruit a person. You collect data about the educational background, job title, and etc., etc. And these types of data are necessary for your purposes. However, how you dis however, if you decide to go and do direct marketing, you don't need to store information about education. You need to simply erase it. Another important aspect is that the purpose limitation principle prevents you from using personal data for a new purpose if they are incompatible with the original purpose you identified. And if your legitimate interest is strongly linked with recruitment, you cannot use personal data for other purposes. You'll just fail to meet the obligations related to legal basis. And where do you need to specify the purpose? And of course, it should be uh, defining the purposes is essential for a balancing test. It should be the part of the balancing text document, and you need to specify it in your documentation, in your privacy policies, and of course, you'll need to provide this information to individuals. Think about your privacy information, how to include the purposes there. So the third principle is called Uh, the third principle is called data minimization principle. And this, the, keep in mind that categories and types of personal data must be compatible, of course, with a purpose, but all unnecessary data must be minimized. Always ponder, do I really need this particular data to reach my purpose? Can I justify the data being processed? And if you are recruiting, you need very limited data to make your choice or present a profile to your client. You don't need a personal ID or special categories of personal data, no biometric data, and think that you always need to justify any category of data that you handle. Supervisory authority may request you to justify why you handle, for instance, identification number, or why you need it, and you'll need to come up with an answer. And then another important element of the minimization principle is getting rid of all the data that are no longer needed. If for a particular position you've considered 10 candidates, you picked one, and unless person is not giving his consent for willing to be remembered, or just to be considered for another position, you must delete the data about these 9 unsuccessful candidates. You cannot store data just in case. Any processing must be justified. And introduce and minimization routines to find unnecessary data and either anonymize it, meaning render it impossible to identify the individual, or simply erase. If you have personal data in your emails, after you've hiring a person, you receive a bunch of CVs and you go through these CVs. Then you found the person. then delete the rest of these CVs. Unless you have a consent. Yeah, it shouldn't be some special GDPR for Estonia. The laws are now fully harmonized, but maybe they have the specific laws, and then we will follow the application of whether they are in conflict or not. Yeah. Next principle is accuracy, and it's maybe less relevant to the recruitment process, but basically it states that companies should, whenever possible, ensure the personal data is not incorrect or misleading. And if you discover that personal data is incorrect or misleading, you must take just reasonable steps to correct it or erase it as soon as possible. And the next principle is a storage limitation. And it's very similar to minimization. So any processing term needs to be justified. You will need to assign retention period for each data you have. And we have question, and what prevails then, GDPR or local laws? Very good question. And if we're talking about Europe, we have very, very important case law, Cassis de Dijon, or on our the fundamental case law suggests the supremacy of European law. And what's the difference between regulation and directive is that directive must be transposed to the local laws, but regulation has a direct application. So the European regulation would supersede the local laws, and it will prevail. Yeah, but GDPR has a direct application. Now it's enforced. It's basically a law in each of European countries. Yeah, and you can go to court and say, well, this is the law. Uh, yes, Nicola is right. There is actually there is very limited ability to change the GDPR, to apply some principle. For instance, it's related to data subjects, age, of what age you are considered to be a child, and but main principles will remain the same, and GDPR will not be have this special interpretation across countries. And directive were subject to interpretations uh, and different local laws that make even contradict to that. But GDPR will have a direct application to member states, and I see very little interpretation of the terms. But application in case law will may suggest otherwise. We'll follow the court practice to see to what extent some of the principles are applied differently and just among member states. But we'll see. And about the storage limitation, you need to assign the term to each personal category of personal data you use. Always think from the perspective, what principles or criterions I use to define retention? How I'm going to explain why I kept data for so long? And this can be a real a real struggle to assign an expiration date to each data category. And let us return the example with 10 candidates. Upon assigning the retention period, you're probably interested in retaining the data about the best candidates in case of the chosen candidate fails during the probation period. But in this case, I would suggest that you secure your ability with consent. When there's a successful candidates, but you want to save data, approach them and ask for consent. Then it's a sixth principle, which is called integrity and confidentiality. And this principle requires companies to apply a controller to apply appropriate technical and organizational measures to protect personal data they process. But it's not easy as it seems. The GDPR does not define the security measures that you should have in place. It requires you to have a level of security that is appropriate to the risk presented by your processing, and it may be very hard to define what is appropriate. And doing this, you need to assess your data security risk. You should review the personal data you hold and the way you use it in order to assess how valuable, sensitive, or confidential it is, as well as the damage or adverse effect that may be caused if the data is to be compromised. And what is important, what kind of organizational technical measures GDPR is talking about? I always keep saying this, that awareness is the key. You must have very strong security awareness. You should identify a person with a day-to-day responsibility for information security within your organization. You make sure that the person has the appropriate resources and the authority to do the job effectively. And you should consider having an effective information security policy to make sure you outline the security standards and appear as one uh, as a company which values security and encourage information security. And of course, technical measures you apply will include both like physical access management, IT security. It's a basis that you have to apply. It's a system, the system security that there is a security of your networks, information systems, especially those who process personal data, especially if there is a sensitive personal data. There must be a data security per se, security of your data that you hold within those systems. For instance, ensuring appropriate access controls and information that for all information, that access must be granted on a need to know basis, and there must be certain controls such as password protections, password strength, and other access management uh, controls. And of course, it's an online security, and that the security of your website and other online service if you're using any. And you're probably wondering that what happens if you delegate, outsource part of your processing functions to a third party? What to consider if you're using processors, such as AmazingHiring, for instance. First of all, you need to ensure your processors are following GDPR requirements. And you must choose a data processor that provides sufficient guarantees about its security measures. Ask them what security measures you apply, how you ensure the data is safe, and in accordance with the Article 28, you'll need to enter into a written contract, which has to require the processor to undertake the same security measures that you would have to take if you were doing the processing yourself. And you should ensure that your contract includes a provision that processor makes available all information necessary to demonstrate compliance. And if you probably already have the contract in place, but if you don't, look at the Article 28, Section 3, and just take all the provisions it's very helpful to come up with a draft. And with that said, we're now discussing demonstrating compliance, and it is accountability principles that pops in the mind. The last principle, and it states that companies must be able to demonstrate compliance by adopting comprehensive policy documents, of course, processes for handling data subject requests, and reporting security breaches to keep records on the data processing activity, and ensuring appropriate information security by default and design. And of course, to have a strong awareness culture within your organization. And you need to have documents, you need to have the ability to prove that you're following GDPR, that it's ingrained in your organization, that you have very strong awareness, um, and you are GDPR compliant. So that's about the principles of processing with respect to recruitment. And now I believe we can take some of your questions, and if you are willing to ask questions, do it now. And
Yes, Elias, I think you need some couple of minutes to catch up with all the questions and discussions. They are quite hot here, and I really wanted to reach out to you guys and say a big thank you for participating in discussions and helping providing answers. That's very valuable. While Eli will be reading the questions and answers to come up with his comments on the topics mentioned. I just wanted to say that from our end, we have spent quite an enormous amount of time and resources to make sure our search engine for technical recruitment, Amazing Hiring, is GDPR compliant and you can use it freely for your sourcing. We have put together all the information at our website, and you can see the link now on the screen. There is a GDPR section where we added our white paper, which is the main document which outlines our vision, which outlines two main principles that we built our compliance strategy. Just a short explanation. We base all the information in our system on publicly available parts of a person's profiles in the internet. Yes, thank you, Daria. And also, the second thing is that what we do in the system is that we do it on behalf of our customers, and we believe that our customers are GDPR compliant. And when we when we sign a contract, we also sign a DPA, and all of the main GDPR principles are there. Just let me read the questions. Yes, so that's Nicole. That's exactly what I was answering right now, and we have a lot of detailed information on our website. Yes, so most probably that we rely on the consent that the person has given to the professional network where when they were registering, they agreed to showing some part of their profile to the web, to the third services, including search engines. We are the search engine, and we re-index these publicly available parts of profiles on the regular basis. Okay, so one more thing is that we wanted to give you guys an opportunity to test our tool, the promo code webinar 0806. And this is the promo code for an extended 2-week subscription. And also the link to request demo is AmazingHiring.com. Elias, have you managed to
yeah,
read?
some of the questions,
Mm-hmm.
yes, can begin with
Let's take one by one.
Nicola's question about the clean and understandable language. Uh, it's a very good question because generally English is fine, but if you're doing business only in certain markets, for instance, you're doing business in Estonia, you need to have a privacy policy in Estonians. And actually, it corresponds with the consumer laws that if you are doing business, you should have the local language support for all your documentation. But when it comes to recruitment, it probably is depends on the market and when you're operating in when you have your principal business. If it's Estonia, then you need to have a privacy policy in Estonian language. If you're hiring from person from UK, you need to have it in English. But I wouldn't. It does not necessarily mean that you have to have 27 different privacy policies. That would be insane. And we can move to next question. No, a lot of questions are already answered and better than I have. Thank you. Our lawyers say, Kari, so our lawyers say that you can keep the CV if you ask the candidate employee. Yes, exactly. It's a consent. When you're approaching a person, if a person is fails to proceed with the hiring, then you should collect consent. About the local laws, yes, most probably, of course, local countries cannot be prevented from having their local laws that may be in contradiction to GDPR, and in this case, we may have this, the person can sue a country in if the local laws is against the European norms. But if GDPR is vague, for instance, GDPR does not address the specific term for which you can store data, and local laws are, or local guidelines from a supervisory authority for data inspection, then you can use these more specific laws to the extent they're not in contradiction with GDPR.
There are some more questions, but no worries. Even if we will run out of time, we can add the answers and provide the answers in the follow-up. So maybe Elias, pick a couple more questions that you will be able to answer, because we have eight minutes more.
All right.
Mm-hmm.
I don't see any more questions that maybe we can have it like that. I will reply on after the webinar because it's a lot of discussion and it takes careful examination before.
Okay. Okay. Great. Um,
But
yes.
if you have on the meanwhile just some questions, please send it.
I see that Yala has also asked, is there a possibility to have tracker of online data, name and public profile?
Oh, a tracker. But what does it mean to have a tracker?
Some online track. Yeah,
Please
Yala, could you please specify? And also,
elaborate.
yes, also Vladimir asks, what is your take on DPAs? Are they really necessary?
Yes. Well, um, yes. If the processing, the Article 28 states that if the processing is if there is a processor and controller relationship, and that's actually a very good topic, and to cover that, and I'll need another hour, but it's a very good question because DPAs is essentially an ability for a controller. Controller is the party that defines the purposes of processing to impose contractual obligation to its processor. And if there is a processor-controller relationship, you must sign a DPA. That is mandatory by law. But what is processor and controller relationship? If you are an employer and you are transferring the data to insurance company, which itself defines the purposes of processing because they have their um, own policies and legal obligations, then you are not a controller. You're a controller, and insurance company is a controller as well. In this case, you don't need to have a DPA. You need to have a strong confidentiality terms. You can probably sign an NDA, but not a data processing uh, agreement. For instance, you have employees and you send flowers. And to do that, you send the person's name and surname to that flower company. Are they processors of personal data? Well, not really, because they are controllers themselves. They decide what to do with this data, how to write it on a piece of paper, or they're making, I don't know, cakes or something. They are themselves deciding how to act with the data. Um, in this cases, you don't need to have a data processing agreement. That would be insane to sign the DPAs with each and every company that you share data with. Only the processors, if you are a controller or you are a processor. And there is a good question: who's responsible for signing DPAs, to initiating signing DPAs, controller or processor? And in accordance with Article 5, Section 2, accountability principles, it's a controller who must uh, identify the need to have a DPA and sign it. But if you are the party who decides how the personal data is processed, you should probably look what kind of vendors, what kind of processors you use, and sign the DPAs with them.
Elias, I think we only have a couple of minutes to take the last question. I think the Eric's question is really quite good. What would be the procedure and actual responsibility? But if it's a very long topic, let's take it in the follow-up. And also,
Okay.
yeah, Nicole asked a couple more questions about our amazing hiring strategy, and I would be happy to follow up on that. I just think we wouldn't have enough time. We have only 4 minutes left. So we will add that in the follow-up. Thank you everyone for cool questions.
All right.
So maybe Elias, if you can just briefly comment on the last question, um, that we can still take within the 1 hour time frame.
Okay, I see Eric asked what will be the procedure and actual responsibility for a breach of GDPR requirements in recruitment. Uh, I'm not sure that I understand what is meant by alternative way, but okay, not according to GDPR. Well, of course, the company you're working for will be responsible if case it's their principal business, and if perhaps you are using source that is not, or you don't have a legal basis, uh, then uh, then of course company will be responsible. But if you could elaborate what is meant by alternative way, I would elaborate on my answer. Okay, alternative way, I just have the contact details. And to do that GDPR way, you'll need to include all the information. You'll need to specify who you are. You'll just need to follow the rules for addressing a person. That you specify who you are and the source from where you took the personal data. But if it's some source that you don't want to mention, or the source, but you still have to do it. You just still have to do it. And then it's the person who will decide, well, is it lawful or not? Any person can file a complaint against you that you've used data from the unlawful source, that he left this data not to be used for recruitment, and you cannot avoid from such people. You cannot avoid from individuals exercising their rights or thinking that their data is used unlawfully, and it's the supervisory authority who that therefore needs to be addressed and need to investigate this on a case-to-case basis, and then the responsibility will fall on recruiter, on the recruitment company, on the organization. If you are recruit HR in a company, then the company would be fined, because company hired a recruiter, and company must have in place the policies. Company must um, um, be responsible for having the sufficient information for the company's data management policy and its information security, and HR is representing the company in this sense. So I believe that company would be um, held accountable for this.
Thank you very much, Elias. We need to finish now, so we will try to answer all the questions in the follow-up. We definitely don't want to consult on how to approach candidates in the alternative way. That's not the point of the webinar. We really advise you guys to follow the rules, comply with GDPR, and use all the recommendations that Eli has provided today. Thank you very much, Eli. Um, that
My
was
pleasure.
really insightful. I hope you guys enjoyed that. It became a little bit more clear for you. In our follow-up, we will add the questions and the short answers, so it might take for us some time. However, I think then there will be really more value in the follow-up. Um, so have a nice weekend, everyone. It's Friday, so see you soon. Maybe someone in SourceCon, and thank you. Bye bye. Thank you. Thank you. We're really glad that it was valuable. Thank you. Bye bye.